Good morning. Good morning. Glad to be here. Good morning to everybody.
All right.
And I hear we're going into another classroom too. So
You are streaming live about 50 feet to your left.
Wow. Terrific.
Modern technology. One of the things I would really like for the students to hear, just to kind of begin at the beginning with you, is how it came about that you went to law school, and in particular, how it came about that you came to Mercer.
Well, good morning, everyone. It's a long and checkered story, but I grew up on Long Island, went to school there, and had my first semester of college at St. John's University, which bored me a little bit. And so I enlisted in the Navy when I thought that the Paris peace talks were going to work out and that I wasn't going to be shipped to Vietnam. I was right. I became a corpsman in the Navy, which is the equivalent of a medic, which I did for about 4 months, and was sent to a Navy prep school, Naval Academy prep school in Newport, Rhode Island. Went from there to Annapolis, where I was for a couple of years, and that period is significant because I met a fellow from Dothan, Alabama. Now, being from Long Island, I had certainly not heard of Dothan, and barely had heard of Alabama. But we became great friends, went down to his hometown. I met my wife there, and she was going to Auburn. It seemed a lot more fun than Annapolis. And so I ultimately left Annapolis and went to Auburn. And while at Auburn, I was an English major, trying to decide what to do next. I thought I was going to teach English. And I was registering for final class and noticed that the pre-law curriculum of programs and classes was similar to what I had taken. And from that very sort of serendipitous thing, I never planned on being a lawyer, never knew a lawyer. Just from reading that, and I had taken a course, I guess it was constitutional law course at Auburn, and read a book called Gideon's Trumpet by Anthony Lewis. Good book. Fell in love with the operation of the United States Supreme Court, the whole background of case law, and decided to go ahead and pursue that. I did. I went into the counselor. I said, what's involved in going to law school? He said, well, you need to apply. I said, okay, good, I've got that down. You need to take the LSAT. And I said, when is that? And he said, Thursday. I said, all right, do you think I can register? And we did. So I did, and ended up heading down the road to law school. At Auburn, and this is a final answer to your question, at Auburn, there was a law school fair. Back in those days, you didn't have, websites and other things to introduce yourself to schools. The schools would come to the colleges, and they'd set up a big tent, and there'd be a whole bunch of law schools lined up. Well, the very first one at the door as I came through was Mercer University in Macon, Georgia. Here we are. And there was the fellow that I met was a teacher by the name of Forrest Mauston. Just a laid-back dude with a beard, long hair, very nice guy. Talked to me a bit. But the most compelling thing that I learned that day was that to apply to Mercer was $10. $10 application fee. Everywhere else was a lot more than that. And I said, well, just because it's a bargain, I need to do this. And I did. I applied. And maybe a couple of weeks later, I got a letter from Mercer, and it said that if I would come, that they would pay my tuition for 3 years. I said, well, I was married at the time, and I still am. And I said to Helen, look, I applied. This guy was nice. I applied. I've got this letter. We had to go look at this. I said, look at this building. This is a nice-looking law school. This might be the real deal. So we drove from Auburn to here, met everybody, met the faculty, and just had that Mercer feeling right from the very beginning. The sense that here they had reached out to me with this letter. I was not I did okay on the LSAT. I did have a good GPA at Auburn, but we're not talking any rocket scientists here. Yet this school reached out to me, and I thought we need to reciprocate. So at least we'll come down here for a year and see what it's like. And I loved my experience here. I felt like these teachers cared about me. I felt like I loved learning the law, to tell you the truth. I used to be in love with case law. I'm over it now, but there was a period of time when I was. But that's how my journey came to take me to Mercer.
Well, and you've given back to Mercer over the years in all sorts of ways, and we appreciate it, especially your new job as chairman of the board.
Yes, well, I'm really honored by that, and I have, I guess I'm in my second term as a trustee. I grew up in the law under Griffin Bell, who was a graduate of this law school in 1948, and under Frank Jones, two tremendous luminary lawyers that were in King and Spalding and had a great connection to this law school, Bob Steed as well. And so they kept me centered and anchored to this school for all those years, and I did a number of things, and I've been on the board. Bill Underwood said that it was a great day for Mercer to break another glass ceiling by letting a Yankee be the president, be the chairman of the Mercer board. But it really has been a good thing, and I have tried to give back to Mercer what it gave to me, but I'll never succeed. But I will continue to keep trying. One of the things, they gave me that scholarship for those 3 years, and I never knew what that was or what that cost. And I went back and said, I want to know what it was in dollar terms, what was the tuition during that period of time. And it was remarkably low. It was like...
Don't say it.
very low compared to now. And I said, well, I'd like to give that back so that at least there's something there that they can give to another student down the road. So it's been a long... Mercer invested in maybe what I am. It was a big turning point in my life to walk through that tent and find that charitable guy there. And the $10 application fee, all of it fell into place, and it's just made a huge, huge difference to me.
And it's worked out for you so far.
It has so far.
So far. Well, and of course, as you walked in this morning, you walked past portraits of Griffin Bell and Frank Jones and Bob
Yes.
Steed and Mr. Steed's bust that is now in the entryway. We'll maybe have a chance to talk about them and their influence on your career. I think it would help the students to have, in terms of context, for you just to kind of talk a little bit about your career. You spent it entirely at King and Spalding.
Yes.
The kind of work that you have done, and a little bit about what you have enjoyed about that. You're one of our big firm lawyers. We have all sorts of lawyers that come and visit with us. But if you could talk a little bit about the kinds of things you've done and what was fun about it.
Sure. Of course, we're in a changing world, and the model that I worked through of going to a big firm and becoming a partner after a number of years and working on the matters I did was the model of the 80s and 90s and early 2000s. I think we're seeing a changing law firm world and a changing law market generally, and that you guys will all be on the cutting edge of that change. But back at the beginning of my career, I knew that Frank Jones and that Griffin Bell and Bob Steed, who I liked enormously, they came and talked at the school, were all at King and Spalding. And I thought that's where I should go. I didn't realize that King and Spalding had not hired any summer associates from here, nor did I realize a number of things I'll tell you about. But I applied there. I interviewed in 1979. I did get a summer job. And at the end of that summer, I got an offer, which I thought that I richly deserved. I thought I worked hard, did good work, and only came to find out 5 years later that my getting an offer was extremely controversial. And not because of my work, but because of what I wore. I was sad to find this out. And I found this out. I was in a restaurant in Hollywood, and a gentleman walked by dressed in a white leisure suit, white coat, white shirt, white tie, white pants, white shoes. I was with one of my law partners, and he said, "Look, Doc, he looks just like you used to do when you were a summer associate at the firm." I said, "What? No. What are you talking about?" He said, "Oh yeah, you had a particular suit that was sort of like that you wore often." And in the recesses of my mind, I said, "That's right. That was that damn good-looking Manilla suit. I had that." Yeah. And he said, "Yeah, you had a chocolate shirt and a big white tie, and you wore that thing 3 times a week." I said, "Well, what were you doing, taking notes? Why did you remember this? He said, it was the most controversial thing at the firm. I said, and no one ever told me nothing. I said, this can't be true. I went back to my friends, and I said, let me ask you just anything. Was there ever any issue concerning and these people would cry, they were holding this secret, and they didn't tell me all these years. And so here I thought I was going to be welcomed back. And instead, on the day that I came back to the firm, as I understand it, many faces were pressed up to the windows to see if I was coming back in that Manilla suit again. Now, I probably would have, I liked it. I would have worn it for a long time, but happily I grew out of it. So that saved me. But I ended up in the litigation department and worked on a variety of things. What I really have loved about my career has been the variety of things that I've worked on. And I would sum it up by saying that from moment to moment, I would focus on trying to create some great work product in a particular matter. That's been my entire career. I'm really devoting myself to it and want, with a sense of pride, what I'm trying to create, whether that be a cross-examination, whether that be an argument to the Georgia Supreme Court, or whether it be a brief. But I began my career defending Hardee's, who was being sued by a woman that said that Hardee's had stolen her biscuit recipe. And I remember being at the office and calling home to Helen and saying, Helen, what is the difference between baking soda and baking powder? And she said, where are you? I said, I'm at work. Come
This
on,
is billable.
Help me with it. Help me with this. And my theory was that you can't have a property right in a recipe, and that for biscuits, there's got to be other recipes out there. Well, I had Mrs. Crawford's recipe, and I found many others out there. I had Hardee's recipe. Hardee used vegetable fat. She used lard. There were a variety of differences. So ultimately, we won. I did get summary judgment. And they showed a big article in the paper and said, lawyer boxes poor woman about the head and shoulders. I said, what? No, I was just arguing you can't have a property right in the recipe. But in that case, I ended up, there used to be a woman by the name of Natalie Dupree who worked at Rich's, and she was a cooking show type of person. And I had her class cook those two biscuits, Mrs. Crawford's and the Hardee's recipe, and have people tell them whether they tasted the same or not. And of course, these people, they loved baking biscuits, and they were distinctly different. They tasted different, and I ended up getting summary judgment. That was the beginning of my legal career. That case had hung around maybe 6 or 7 months, and nobody was touching it. And I got into it and said, my God, I'm pursuing the heck out of this. And it was quite fun. I still have that opinion. As it turned out, the judge who wrote the opinion was a lover of biscuits, and so it begins like this: biscuits are known to the Southern culture, and then he drops a footnote. The footnote goes on for pages. It cites all these kind of people how the biscuit came to life. None of this was in my brief. I'm so glad he went my way. It could have been damaging, but anyway, that was case number one. I then had a series of cases. I'll just tell you maybe about 4 or 5 of them because I give you the difference of things. In 1985, E.F. Hutton, which was then one of the great brokers in the world. There used to be a commercial that said, you'd see a big buzzing room, people talking, and then there'd be a broker from E.F. Hutton, and they'd say something, they're going to give a tip. And when they did, the whole room stopped and said, when E.F. Hutton talks, people listen. That was their tagline. Biggest brokerage house in the country. Well, it's too complicated to explain all the details, but they had a cash management practice where checks that were written in Denver and California and Texas needed to take time to get to New York, which was their money center. And they were trying to figure out how to capture that lost days float of that check. And they eventually came up with a system of basically overdrafting various banks around the country intentionally. And ended up having 2,000 counts of mail and wire fraud that they pleaded to. This was huge news that E.F. Hutton did this. They had retained Griffin Bell to do what was called an internal investigation. Was one of the very first, where a company hires counsel, typically under the banner of the attorney-client privilege, investigates what happened and reports to management so that they know who to blame and know how to avoid it in the future. That's basically the purpose. But Judge Bell's report was not going to be under the attorney-client privilege. This was going to be issued to the public. And so, for a period of 4 months, we young lawyers, I was a fourth-year associate, third-year associate, ran around the country interviewing all kinds of people at branch offices and regional offices, trying to figure out where this cash management practice started, how people were abusing it. Basically, what it was the branch managers, if they could have a certain amount showing as interest in their bank accounts, they would get a share of that. Certain branch managers get a share of that. That sort of the greed drove this problem. In any event, Judge Bell does this report. We write it up. It's a big, thick report. It's called the Hutton Report. And we told the judge, when we said, Judge, we have been very, very careful not to use the word criminal conduct anywhere in this document. We've said it violated the company policies. We said that it's not proper, but we haven't called anybody a criminal. We haven't said it's a crime because we don't want to be sued for libel and slander. We've kept that out of there. So I'm sure you noticed, Judge, it wasn't in there, but I wanted to tell you it was intentionally not in there. He said, okay, thank you. So we went to the press conference. This document was released at a press conference in Washington. And the first question that Judge Bell was asked was, did you find any criminal misconduct in the course of this investigation? Yes, he said, yes, we did. I said, holy camoly. And they said, well, who was that? And then he lists 8 people, the first 2 questions. And I sat there. Okay. Well, 3 years later, Judge Bell was sued by one of the people he named for libel and defamation and slander. And we could not get summary judgment on it. We had to try the case. And it was tried before a federal judge in D.C. There's Judge Bell at the defendant's table. And here's the witness in the box for 4 hours, and others in our firm. What I didn't really appreciate was what a hero Griffin Bell had been as the Attorney General after Watergate, and had such a big impact on the civil rights movement in the South, that he was a very popular figure with that jury. And after a 3-week trial, the jury went out for half an hour, came back, verdict in favor of Judge Bell, and they asked if they could have autographed copies of the report. The alleged slander. So that was quite the case. The next sort of big matter that we had was in 1992, Dow Corning sold silicone breast implants, and they had all kind of problems with these. And so I, for a while, became an expert in silicone breast implants and other variations of them. And it was a huge internal investigation that we did, but that was protected under the banner of the attorney-client privilege. That took about a year's time. The next thing that took place was on March 24, 1989, the Exxon Valdez ran aground. I'm sure you've heard of the Exxon Valdez ran aground in Prince William Sound out in Alaska, spilling 11 million gallons of oil into the pristine Prince William Sound, covering up the poor little seals, the birds, ruining the fishing there for a while. And that case has gone on for a long time. Just recently, maybe a couple of years ago, was a Supreme Court decision on punitive damages. But our job was to figure out what happened out there. How did this happen? And basically, there's a well-known shipping lane obstacle up there in Valdez, Alaska. Bligh Reef, it's called, from Captain Bligh, the Mutiny on the Bounty. This reef is well known. And on this particular night, the Exxon Valdez went out of the harbor, this big, huge, 900-foot-long ship coming out of Valdez Harbor, and there's bits of ice bobbing out there in the water. And there's 2 shipping lanes, which you're supposed to stay in, but there's ice bobbing in there. So the Captain Hazelwood, comes out later that he's an alcoholic, and that he has a few non-alcoholic beers on the boat, but people said that he had drank things. But he comes out and he said, well, I'll tell you what we'll do. Let's just steer around those ice, and then come back into the shipping channels maybe about 20 minutes from now, I'm gonna go down below. So he goes down below, the third mate is up there, and he's got the helmsman up at the wheel, the helm, and he sees Bly Reef ahead, and he starts to tell the helmsman to correct the course and turn back into the shipping lanes. The helmsman said that he heard the two commands, that he did what he was supposed to do, but the ship did not change direction. The Valdez went directly right over Bly Reef, and like a knife under it, it just ripped open the bottom of the ship, and this huge amount of oil just went everywhere, and it was just, that was a disaster. Because Hazelwood was an alcoholic, there was allegations that management should have known. They were trying to figure out what exactly had happened, what orders had been given, how did this come about. And in 1991, I went to the North Sea as a lawyer, practicing lawyer. That's what you do. I went to the North Sea on a cold day in February. Even my hair was blowing. And I was on the Exxon Mediterranean because the Exxon Valdez was so ashamed, it took itself over to Europe, changed its name to the Exxon Mediterranean, and was running oil from Rotterdam down to Cadiz. And so I went on that vessel with Sir Hector Lang, who was a pilot in World War II, a very vigorous guy. He was the head of the United Biscuits Company, there's biscuits again, that owned Keebler and other things. But anyway, he and I were on there because I wanted to test out one thing. What I wanted to test out was, if I had that vessel on autopilot, and somebody gave me a command, i.e. Sir Hector, because there I was trying to play the helmsman, and he gave me a command to turn back into the shipping lanes, what would happen when I turned the wheel? What would happen to the autopilot? And the answer is nothing. That if you do not disengage that autopilot, unlike a car, you know, where you're doing cruise control and it'll change it. So, and my own theory was that for a little while they were on autopilot and didn't realize it, and I thought they had to disengage it because ultimately the ship did make a turn, but no one on board ever said no. No one ever said that was what took place, or that they suddenly realized the autopilot was on, or anything like that. So it was quite the mystery. We spent 2 years putting together a report that was also under the privilege, but it was quite, a very exciting and interesting thing that I did during that period of time. I then had a series of cases here in Georgia, 2 of them of significance. There used to be a gigantic tobacco plant here. Brown & Williamson's tobacco plant was here, opened in 1975. And in 1980, Hal Lewis, who's now retired from Mercer Law School, but spent a long career here of 30 years plus, was one of my favorite professors, a brilliant guy. He sued Brown & Williamson for race and sex discrimination at every job, every promotion, hiring, transfers, everything about it, salary. And as fate would have it, we ended up defending Brown & Williamson in that case, and I ended up against this professor that taught me Title VII law. We had this, this battle right out of the box, the very first case I worked on out of the law school. Now, when Hal filed that suit, under the Fifth Circuit law, you were allowed to have, quote-unquote, across-the-board class actions, where someone who was discriminated against in hiring could file a suit and say, they didn't just discriminate against me in hiring, they discriminated against everybody in every way, in every form, in testing and promotions and payroll, and we're bringing a quote-unquote across-the-board class action. We defendants argued that you shouldn't be able to have a person that only has standing to challenge hiring and let them challenge everything else. We ultimately prevailed in that argument in a case called General Telephone Co. v. Falcon in the United States Supreme Court. Well, that was not the law when the case was brought, but by 1982, we were in control of the law. And Hal would always say to me, how did you get so lucky to have a law chance? So, well, these things happen. But the case lasted 12 years. When I began the case, I had a mustache and a comb. I occasionally used a comb. I had some hair. I'll never forget being in a barber shop in Los Angeles, and I was looking in the mirror, and I looked at the mirror behind me and said, the hell? I had no idea that I was as bald as I was. I would see this area. But anyway, during this case, I went from mustache, no hair, completely bald. 12 years I was on the case. I started as the guy working, doing the documents, and I argued the case ultimately in the 11th Circuit, in which we had a total victory. But that was a Title VII class action, very interesting. But then there was a series of cases here in Macon, in the surrounding areas, where families who sold their houses in the 50s and 60s and even 40s claimed that they sold to a clay company, a kaolin company, that bought their property without telling them about the valuable minerals below the land, and bought their property for way less, they said, than its true fair market value. So you can imagine the issues we had, right? The statute of limitations, no duty to disclose, a whole variety of things. The cases went on for a long time. One of the ways we won the cases, we had summary judgment in them, was the dead man's rule. You think that when you're in class and you hear these crazy things, the dead man's rule and the mailbox rule, I'm going to come to that in a moment too. You hear these rules that say, well, they'll never have an impact on your life at all. Well, the dead man's rule, I was thinking about that. I said, basically these cases are contending that my people from Southern Clays who bought this property did not tell these people anything about the fact that he was buying it for the minerals that lay beneath it. But under the dead man's rule, if the person that you contend you had a transaction with is dead, unless you have it in writing, you can't testify as to what that person said to you. That's because he can't defend himself. So my theory was the whole case turned on their premise that they weren't told something by my executives, but they couldn't have that testimony because it's barred by the dead man's rule, and we won on that basis. I would put that argument in there, and Frank would say, "I don't know about this one, Doc. Let's see if it has some wings." But it ultimately did. Around this period of time, I had a phone call one day, and this will sort of round it out. The other thing I do is a lot of tobacco litigation, a lot of asbestos litigation. It's much less exciting. I've done that for a number of years, but this is my last example of this interesting and wild career I've had at King & Spalding. The phone rang one day, and it was a young man, 23 years old, and he said that he had broken the code on a scratch-off game, and that he thought he was going to win millions of dollars. And he said that he had one of these cards, and he could show me how he broke the code. And basically, the card was 8 boxes designed around 8 weeks of Monday Night Football. And there were 7 silver bullets for field goals and 7 silver bullets for touchdown. For touchdowns. And you had to scratch off one of those silver bullets, and if it happened that in that game there were 2 field goals and 4 touchdowns, and you happened to scratch off the 2 and the 4, you would win that game, and there were 8 games on there. You could win up to 16 points. What this guy figured out was that these cards were not all random number generated, but they were made from a limited number of patterns. He figured out that if you took the game said, if you scratch off more than 1 football, that voids that game, but you can play the rest of the card. And so what this guy, Frank Maggio was his name, what he figured out was, if he scratched off the whole line of footballs, that would identify the numerical identifier for that card. And if he could get a whole bunch of cards and stack them up, he would be in great shape. Now, this scratching of these little cards takes some time. Why would they do this? What would be the incentive? Well, the way the rules were written, if he won 7 games, he's going to lose the 8th game, right? But if he wins the other 7, the prize is $5,000 a card. $5,000. Well, he had 4,000 of these cards. He was a soap salesman. He went to the various grocery stores, got people to give him these cards, and once he figured this out, he got his friends, we called them the scratch gangs, scratching off these cards to make them winners. He got cards from butchers. He got cards from people in the produce section. All kind of cards he had. And I ended up taking the case on a contingent basis. We argued that the game itself was a contract, that the contract being that the reason they were putting it out was to advertise the product. They wanted people to spend time. It was Beatrice Foods, by the way, that put this out. And Beatrice Foods at the time owned everything. They owned Skippy Peanut Butter. They owned Swiss Miss Hot Chocolate. They owned Manwich, Sloppy Joe. They owned Fisher Nuts. They owned Stifel Lights. They owned everything. And these cards would have put out the message that they owned everything. And on this particular card, they had these the brand was on them. That's why Frank discovered him, because he sold soap at these stores. He was worked for Procter & Gamble. Anyway, we sued for $21 million because we had the 4,000 cards times 5,000, about 20 million. Now, Frank could never keep his mouth shut and hasn't ever since. And he had gone to before coming to talk with me, he had already told the company that he broke the code. He'd already been on the news to tell them that he broke the code. All the games hadn't happened yet. And so he hired a lawyer in Decatur, and they were about to have a meeting with the company. A day before he told me the story, I said, look, if you want us to work on it, we can work on it, but it would have to be exclusively with us. So you might want to talk with your lawyer and tell him you've got a new one. And apparently we have to have this meeting with Beatrice now because they want to see what you can do. And I remember the Beatrice executives came flying out there from California, and their faces were ashen to know that this big game they put across the country was broken by this knucklehead here in Atlanta. And he showed them all how he had done it, and their faces, and so I looked at them and I said, you know what they're going to do? They're going to revoke that offer. And so I needed to defeat the revocation of offer before it happened with the mailbox rule. And so Frank had all of these 4,000 cards, and I said, Frank, do not answer the door. Do not talk to anybody. You scratch off as many of those cards as you can, and you get them in the mail. And I want it filmed. I want the time, etc. Well, for the next 24 hours, they scratched furiously, and they got $4 million worth of cards scratched off. And they had each of these things had to have they said the card must bear the signature of the winner. Get to that in a minute. He mailed all these things at noon that day, the next day. Beatrice took out full-page ad in New York Times, full-page ad in USA Today, full-page ad in Wall Street Journal, game canceled. I think 10 minutes before that, we had him on film in the mailbox, putting this gigantic mailbox of cards into the post office. Because we had that defense against revocation, I always had it that they couldn't get summary judgment, I thought. That we at least had a claim to $4 million. And to sweeten that up, there's an unjust and unlawful practices act, unjust practices act, I guess it is, unlawful consumer practices act. That's it. That gives you a treble damage remedy if you can prove that there's been a violation of fair trade practices. And what we argued was to put this game out, to let people play with it, and to put those rules on the way they did, to cancel it was a unfair trade practice. Now, we throw that in there just to make, because I thought it was an arguably legitimate claim and made our claim go from 21 to 64 million. During the course of that case, we had the general counsel of the company, assistant general counsel of the company. We took his deposition and we asked him, did you throw away any documents concerning this case at any time? His answer, no. A few weeks passed and we got his deposition back. Now in the back of the deposition is something called an errata sheet. Many times lawyers don't spend a lot of time looking at the errata sheet, but here it came in, and I was a very nerdy little lawyer. It came in, I looked at it, and there was that answer that said he had changed the no to yes. Yes, he did destroy something. So I called the lawyer, said, how come he's changed this to yes, and we'd like to take his deposition again? She said, well, why don't we settle? What do you think about settling? I said, well, we'd love to settle. What do you have in mind? And they came up with some ridiculously low number. I said, no, you tell him to get a date on his calendar. for a deposition. We went up there, took his deposition, and during the course of it, we said, "Now you said here, no. Did you throw things away?" "Yes." "What did you throw out?" "My entire file and all my notes about it." "Why'd you do that?" "Well, I became concerned about the Unlawful Trade Practices Act, and I knew we were supposed to have an odd statement in that game, and we didn't. And I thought the company would get in trouble under the Unlawful Trade Practices, and so we threw it out." I said, "Oh, the deposition is over, thank you." Because now, we had just taken our Unlawful Trade Practices Act claim and really made it into an impactful claim. The only other thing I'll tell you about that case is, remember I said that it has to have the signature of the winner on there? So when you're doing this 4,000 times, you can imagine, my friendly little client, instead of writing the name Frank Maggio out, he would just, just his initials, sort of just one line like this. On the game it said, "Decisions of the judges are final," and Beatrice appointed one of its executives as the judge, their top executive as the judge, very fair guy. And he had this stack of 4,000 cards, and he found them all to be invalid because they didn't bear the signature of the winner, they bore his initials. Now, that was their contention, and they were relying on a guy by the name of Ordway Hilton, a famous handwriting expert in the country. I said, well, I guess I got to get myself a handwriting expert too. So I went down to the Georgia Bureau of Investigation, and of course my theory was, what do you mean? A signature could be X. Back in the day, the serfs would put an X on a page if they couldn't write. That would be their signature. You can't tell me it's just defined as you have to write out Frank S. Maggio. So I'm waiting to see this fellow at the Georgia Bureau of Investigation. I've learned that he's a good handwriting expert, knows this area of the law, and I'm trying to get somebody to combat Ordway Hilton. They tell me he's got a meeting and he's going to take him another 15 minutes. I said, okay, fine, I'll just sit here. Sat in the lobby. I was looking around. There's bookshelves. And I saw a book, and on the spine it says, "Scientific Examination of Question Documents by Ordway Hilton." So I take the book down. I look at the table of contents. Initials. Page 271. And it says, "Initials are a special class of signatures. Please tell Mr. Kelly I will not be needing to see him." And went to take this deposition of this executive. Now, they had not discovered this book. They didn't know anything about it. So we went out there and we asked the fellow, "Now, why did you invalidate all 4,000 cards?" He said, "I'm sorry to do it, but they're just invalid." "Why?" "Because they have initials on them." And the rules say you have to have signatures, and initials aren't signatures. I said, "Where'd you hear that?" "Well, Ordway Hilton, leading expert in the world. That's what he told you." "Have you ever read any of these books?" The room starts. Oh, and at these depositions, they would have phalanxes of lawyers there. You read any of his books? No. You read this book? And read page 271? I mean, and when I read that sentence, oh my gosh, a gasp went out of there. I mean, I'm sure they want to have somebody sent out to kill Ordway Hilton. But in any event, that gives you some idea of the kind of matters that I've had in my career. And I've done a lot of tobacco trials, the two big tobacco trials. I do a lot of asbestos discovery defense these days. But what has been most true about the entire experience is I have always been the one in charge of my own self, my schedule. Believe it or not, in a big firm, there's not a regimen for you to march to. You march according to your own beat, just like you do here. The way in which you decide how much you're going to study and when you're going to study and how hard you're going to study and what's good enough for you. You're your own boss. You're going to find that in the law practice generally it's like that, number one. Number two, I really took to my colleagues and liked them and enjoyed them as people. I've been fascinated by the people that I've worked with. I have also always been enthusiastic about the case that I've gotten. And if it's assigned to us and we're trying to win for our client, well, I go all in. And it makes for a lot of fun. It just does if you just engage that way. And, you know, our firm, when I started there, we had about 80 lawyers. We now have 850. We're all over the world, from Singapore to London to Paris to Frankfurt to Atlanta and DC and Austin and Houston, San Francisco. We've seen extraordinary growth during that period of time, and it's just been a real joy.
Doc, I've got two things to say. One, you're the easiest interview I've ever done. And secondly, I've known you for 14 years, and I've never heard any of those stories.
Really? Wow.
You must have an infinite supply of them.
I can't believe it. I mean, I'm normally repeating myself every
Oh,
day.
no, not at all. You know, in a few minutes, I'm going to let the students ask you questions, but wondering, you know, from your perspective now as a senior partner at a big firm, with the way the legal market has changed, certainly with respect to entry into big firms, if you had any advice for the students, maybe generally and then specifically to those who are thinking about that they may want to enter into a large commercial type, particularly litigation practice. Jim Elliott was here Friday talking about transactional work at Alston and Bird, but you've been in litigation practice the whole time.
Yeah.
Any words of wisdom or direction or guidance for?
Yeah, I think, you know, several things. First of all, the whole world's changing every day. You know, there was a time when we didn't have PCs, and PCs are about to become obsolete, and everybody's going to be, you know, tablets going to replace all it probably has for most of you. And that kind of change you see in the world of technology, I think you're going to see in the law practice as well. And I think it'll give you greater opportunities and flexibility to run your own shop if that's what you decide to do, or to go to a firm either with the intent of staying there forever or with the intent of staying there to learn, train, and go on to your next opportunity. The world, of course, is the world of commerce. There's lawyers needed in business of all kinds. World of government, in terms of both criminal defense, civil defense, state and local levels, also rewarding careers. The world of the big firm model. Now, the big firm model has changed over time. Back when I started, the deal was that you would come in as an associate, and in 7 years, so long as you did your work and, you know, didn't wear any crazy suits, you become a partner. Now, it wasn't automatic by any means, but they did a lot of screening on the front end to be sure that these people who are being hired are likely to be successful, and that at the end of the 7 years you would be elected partner. That standard and test has gotten harder and harder and harder and harder, and you'll see fewer and fewer people becoming both income partners and equity partners. We have a two-tier partnership at our firm. But I still believe if that's what you want to do, if you want to go to a big firm and you are committed to it and that's how you see your career, then my advice to you is to go there, become a part of the fabric of the firm from day one. In fact, this is wherever you go. If you go to a small firm, you go to a mid-sized firm, the day that you arrive there, to see yourself as part of the fabric of that firm. Those clients are your clients. When you're asked to work on a matter, you're there to try to find a solution with the others who you're working with, and just to embrace the experience that you're in. With a big firm, there's a misconception that a big firm has a plan for you, that you're going to do this, this, and this, and you're going to do it on this schedule, and the truth is, it's as serendipitous and ad hoc as the cases that I've described to you. You have to look out for yourself, and I think that whether you go in a big firm or anywhere else, you need to find a mentor who you take an interest in and make them mentor you. There's some people who are natural mentors, and they look for candidates to talk to, but the world is so busy, there's so many contacts, we're all in communication with everybody all the time. It takes some effort for you to go and find someone and say, you know, I like that person personally, I admire that person where they are in their career, and I'm going to actively pursue them to help me, to talk with me, mentor me, give me advice. I think you'll find it to be very rewarding, and hopefully you'll be open to that 5, 6, or 7 years from now when someone's coming out of this law school looking to you to be that mentor. But the most important thing I can tell you is you are going to be the master of your own destiny. What do you want to do? What area of the law do you want to practice in? And how are you going to get there? What's the plan? You know, after Dunkirk, when the boat got the soldiers back to the English Channel, back to England, with all these waves crashing around them, and they had pictures, and they asked Churchill, how could it be that a boat with all these big, gigantic waves all crashing around, how could it be that that boat made it through all that? And how could that be? And they said, well, there's one key point. The waves, they're just going everywhere, no pattern. But that boat had a purpose. That ship had a purpose. And when I tell you this piece of advice, it's not because I lived up to it. I did not sit in law school and say, okay, here's what I'm going to do. No, I am an accidental optimist and tourist on this journey that I've been on. But I've known from coming to this perspective that I shouldn't have done that. And there's a number of my friends who I admire who were much more methodical and said, okay, this is the area of the law I want to get into. I'm going to master it in these ways in addition to going to law school. I'm going to go and work with people who work in that area, and I'm going to pursue that with a single-mindedness. I believe those opportunities are out there in a variety of fields, but it's not going to be something that happens to you. It's going to be something you do. And that's my most important piece of advice. You might also be like me. You know, I just sort of floated around and matter after matter bumped into me, because when I took it on, people knew that I was going to give it my all. Because I've been enthusiastic about it, those matters came to me. And I didn't really go out looking for them. I think in today's world, with the level of competition in there, the streams of different kinds of law that you can do, I think you need to begin to think about it in law school and think, where do you want to go? Where do you want to go? And write down bullet points. What's the plan? How are you going to get there? What are you going to do? How are you going to measure it? I didn't do any of these things. But the people who are most successful do. The people that are most successful in our firm have done that from the beginning. And I would pass that along to you. I know that when you're getting ready for this class or getting ready for anything, you make a plan of how you're going to study. When exam week comes, you figure it out, right? You figure, oh, I got to do this, this, and this. That applies for the rest of your life. And not only for what you're going to do as lawyers, but I think you also need to give yourself a break. You can't be on this plan day in and day out and night after night and day after. You need to have some downtime and put that into the equation as well. And I write in this essay about having other interests outside the law. I think I say in the essay, don't be so fast to go to those so they distract you. I think I say in there, be first a good lawyer and spend those early years being as good as you can in the area that you're in, but have an eye on what are you going to do with your wasted time, so to speak. Where are you going to find another interest that rounds you out? So,
and the students did read your essay in here and know that you are, in addition to everything you've described, a singer-songwriter, and I wish we had time to talk about that. I want to leave just a few minutes here for the students.
Sure.
To ask any questions that they have about that or anything else. What questions do you all have for Mr. Schneider? Yes, ma'am.
Well, Kenneth Spalding is so well known for having major practice teams in various areas of law, but there are some areas of law that are very small, that are emerging, and I didn't know if you might have any insight on what those areas are, what in 10 years, what new teams there might be at King and Spalding, for instance.
And for purposes of the recording, Doc, I'm going to repeat the question. It's just basically asking for your projection out now, maybe 10 years from now, what areas of the law are emerging, maybe the King and Spalding would have teams focusing on or otherwise.
yes, well, we have a healthcare team. We're seeing the implementation of the Affordable Health Act now, but I see that as a specialty area for lawyers for years to come. The FDA, in 2009, President Obama signed into law a statute that gives the FDA power to regulate cigarettes in various ways. And that whole process is now evolving and is evolved into e-cigarettes, I'm sure you're familiar with, and I think that area of the law is you're going to see development. There are a series of statutes involving corporate governance. We saw what happened in 2008. I think that's the law of governing corporations, the law of governing the marketplace. You're going to continue to see that as a developing area. Criminal law is always going to be what it is, but I think you'll have more cases about cybersecurity and people trying to make an effort to steal bank records, and how are we going to use the law to protect that. Intellectual property. You have the whole Google and all that information that's out there. They're printing up books, and how do you defend information and keep a valuable property right in this information in this kind of age where you're awash in it. So every cutting edge thing that you see in the news is going to be an area of the law. And, that's an interesting example. You may be interested in IP, intellectual property, and the patents that go with it, and how from this place and this time are you going to go and pursue that and get there. I think that requires doing some study, talking to people who are patent law. I think we're going to see a lot of expansion in patent law as well. But and then good old traditional, what we do is litigation. There's always going to be people battling, whether it's products causing injury, whether there's contracts that's gone awry, whether there's knuckleheads scratching off cards. There's always going to be that in this world, and you're going to have the cases that are, Bank of America and billions, and you're going to have some lower tier, like $1 million, $2 million cases, or even less. And that work is always going to be there, I think. And the question is, how best to, if you want to litigate, do you do that on your own? You want to be a plaintiff's lawyer, or a mix? Do you do it at a small firm, medium tier firm, big firm? The choices are yours. I think that there will be much more of ability for lawyers in the current age to market themselves, have their own practice, get a network of addresses and clients. I think all of the application of technology is continually applied to the law and make it, I think in some ways, easier to be a business generating, functioning, and effective lawyer. So.
Time probably for one more. Yes, sir.
You mentioned that whenever you're a lawyer, you pretty much you make your own schedule.
Yes.
In sorts. How do you think that your day-to-day schedule, in general, has changed as you've moved up?
That's great.
How has your schedule changed as you've moved from being a brand new lawyer with hair and a mustache to where we have arrived today?
Well, first I'll give you the numerical answer, which was that I probably worked, 2,700 hours a year on average when I was in my first 10 or 12 years, and now I work about 1,700. So it's much better pace now. I'm a senior partner. I'm also intentionally slowing down and not chasing all the kind of things that I did back in the day. Do you need to work 2,700 hours? No. Will 2,700 hours kill you? Yes. A good target is about 2,000 hours, billable hours, which means you probably need to spend 2,300 or so getting that done. A normal schedule would be something in the neighborhood of between 7:30 in the morning till 9 starting, and working to 6 or 7 at night type of thing. Some weekends would be involved, but like I say, you got to give yourself a break. I would spend day after day after day after day, and I would say, all right, it's Wednesday, I'm exhausted, I'm leaving. I'm going home at 10 in the morning, and I'm not coming back till Friday. And just on my own would give myself a break. I think that's something you're going to need to do. But I think lawyers, we're hardworking people, and we can't expect to have success or advance our clients' interest or grow as people in the law unless we spend substantial amount of effort. If you spend 9 to 5 for 5 days a week, you're going to end up working at about 150 hours a month, right? I think, roughly. And that's a good pace. That's 1,800 hours a year. But I will bet you, and you can let yourself, we had lawyers in my firm who were very efficient, and they would work about that amount of time. I never understood how to do that. I was always trying to find the next, where's the case coming from? How can I figure out how to get around this revocation? I'm always consumed by it, not because somebody's telling me I'm gonna be consumed by it, but I wanna figure it out. I wanna get to the solution. I hope that happens for each of you, that you become so excited by the law, that you become so excited by what you're doing, whatever it is, that you come to work and you're happy about it. You're excited about it. You're proud of what you do. I think this law school gives you a great platform to do that. And I know our first years or second years, Carl?
All first years.
First years. So it's an exciting journey ahead. You will not imagine all the things that are being poured into your head over the course of your 3 years here. I recently was reminded of this 2 years ago, when very sadly, with much tears, I had to take the Florida bar. Everything, the multi-state, so I had to take a bar review course, and said, holy camole, I'd forgotten so much constitutional law, tort law, contract law, real estate law. You know, the rule of Shelley's case, whatever it was. I knew it for about a 2-week period, but it reminded me that what's happening here in law school is an amazing information process, and to treasure it and value it, because it's going to make a difference to you on the road ahead.
The last thing I'll say, Doc, and it's for the benefit of the students, is, of course, this interview will be up on YouTube in the next couple of weeks. One of your older interviews is already up, as you know, and so the students interested in hearing different stories from you about your career, that's up there. But we are out of time. I wish we had more time. But join me in thanking Doc Schneider.